Hello, we're glad you found Michigan Alliance for Families in this video on discipline and students with disabilities, specifically on navigating the manifestation determination review and beyond. Michigan Alliance for Families provides free support and information for families in Michigan who have a child who currently receives or might be eligible to receive special education supports and services. We want to share information with you and try to make it easy to access. You found these recorded videos that are here for your learning anytime you have time, 24/7. You can find more information on today's topic on our website, www.michiganallianceforfamilies.org, by searching discipline. We have regional parent mentors who live where they serve all over Michigan, and they are here to support you. Please do not hesitate to reach out to your regional parent mentor to discuss your family's situation and get more information. We can be reached at 800-552-4821. With that, I'd like to turn it over to Laura to discuss manifestation determination reviews. Thanks, Laura.
Hello everyone, and thank you for tuning in today. I am so happy to offer you this video of information. My name is Laura Zangara. I am part of the intake team with Special Education Mediation Services. We are also known as SEMS. I am also a licensed attorney in both Michigan and Illinois, and I have been working in the area of special education for almost 30 years. I would like to share with you just a few words about SEMS before we delve into our topic for today. SEMS is a grant-funded initiative of the Michigan Department of Education, Office of Special Education. SEMS services are free, they're neutral, and voluntary. We provide mediation, facilitation, and collaborative communication training to schools and families across the state to meet Michigan's obligation under the IDEA, or Individuals with Disabilities Education Act, for alternative special education dispute resolution. Our topic for today is the disciplinary removal of students with disabilities, navigating the manifestation determination review, or MDR, and beyond. A brief disclaimer before we get started. First, these slides reflect general legal standards for the related presentation and are not intended as legal advice for specific situations. Secondly, future legal developments and guidance may impact these topics. Today's agenda will cover students included in IDEA's disciplinary regulations, the Manifestation Determination Review, or MDR process, interim alternative educational settings and special removal circumstances, when functional behavioral assessments, or FBAs, and behavior intervention plans, or BIPs, are required as part of this process, and finally, procedural safeguards and dispute resolution options. We will answer these questions. Which students are included in the IDEA's disciplinary regulations? What is a change in placement under the IDEA disciplinary regulations? What is an MDR? When does an MDR need to be held? Who participates in the MDR? What happens at the MDR meeting? And then what happens after the MDR? And what if you disagree with the MDR outcome or any decisions regarding placement under the IDEA regulations? Which students are included in the IDEA's disciplinary regulations? Of course, students with IEPs are included. Students with Section 504 plans also have disciplinary safeguards, but the discussion today will focus on the IDEA. The discipline procedures for students with disabilities sometimes also apply to students who do not yet have an IEP if the district had a basis of knowledge that the student is a student with a disability. There are three circumstances that establish a basis of knowledge. One is when a parent requests an evaluation in writing under the IDEA and MARS, Michigan Administrative Rules for Special Education, evaluation process. The second is when a parent expresses in writing the need for special education services to a teacher, supervisor, or administrator in the district. And the third circumstance is when school personnel have expressed a specific concern about a pattern of behavior to a special education director or supervisor. There are also three exceptions to a district having a basis of knowledge. The first is if the parent of the child has not allowed an evaluation to determine eligibility under the IDEA. The next is if the parent of the child has refused services under the IDEA. And the third is when the child has been evaluated and determined not eligible under the IDEA. It is important to note that students with disabilities can be removed for more than 10 days in a school year, but if the removals of more than 10 days result in a change in placement, the MDR must be held. A change in placement under the Individuals with Disabilities Education Act for discipline purposes is a removal for more than 10 consecutive school days in a school year, or for more than 10 cumulative school days in a school year if there is a pattern of removals. A removal is any time a student is taken out of their educational setting and not provided an opportunity to continue to participate in the general education curriculum, receive their IEP services, and participate with non-disabled peers to the same extent provided in their IEP. For more information about change in placement and the pattern of removals, please search discipline at michiganallianceforfamilies.org. Knowing when there is a change in placement is important because the change in placement is what triggers the district's obligation to hold an MDR. The MDR is a meeting to determine if the student's behavior is a manifestation of their disability. The meeting is not to address the disciplinary recommendation under the Student Code of Conduct. This is the responsibility of another district decision-making body, usually the administration, the superintendent, or the school board, not the MDR team. Sometimes the actual code of conduct violation has not been adjudicated or ruled on prior to the MDR meeting. Districts will sometimes, but do not have to, wait for the outcome of the MDR before holding that disciplinary hearing to make a final recommendation on discipline. The MDR must be held within 10 school days of the removal decision that results in a disciplinary change of placement. As stated previously, if the district is considering an expulsion, for example, the expulsion hearing can be held before or after the MDR. The 10 school day timeline is triggered by the decision to remove that results in the change of placement. Sometimes the removal or suspension begins before the MDR is convened. And sometimes the suspension or removal is over before the MDR is actually held. Notice of the disciplinary action must be provided to the parent of the student with disabilities in the same manner as it is provided to all students pursuant to the district's Student Code of Conduct. A copy of the IDEA procedural safeguards must be given to the parent on the day the decision is made to remove a student with a disability when the disciplinary removal is a change of placement. The procedural safeguard notice must be provided even if the parent has already received their annual notice of procedural safeguards. The school must also offer the parent a paper copy of the procedural safeguards, even if the procedural safeguards are available on the school website. And finally, parents should be informed of the right to file an expedited due process to appeal the decision that has been made. So who participates in the MDR meeting? In addition to a parent, the IDEA also requires that the LEA or local educational agency representative and relevant members of the child's IEP team participate in the MDR. The parent and the LEA determine who the relevant team members are. Usually this will include a teacher. Often it will include related service providers such as social workers. Ultimately, the school district has the authority to select who will participate from the LEA team. Just a note, SEMS can provide a facilitator to support the communication during the MDR meeting if one is requested and the parent and school agree. Once the MDR has been scheduled and the participants identified, it's helpful to understand what actually happens during the MDR meeting, including what must be reviewed, the questions that form the basis of the determination, the potential outcomes, and then what must be done as a result of the outcome of the MDR. The MDR participants must review all relevant information in the student's file, including the IEP, observations from those working with the student, and any relevant information provided by the parents. This list, of course, is not exhaustive and can include evaluation reports, private therapy reports, progress notes, and really any other relevant information. Congress intended to assure that the manifestation determination is done carefully and thoroughly with consideration of any rare or extraordinary circumstances presented. Teams should avoid relying heavily on only one source of information when making this determination. It's also important to review details of the behavior that resulted in the disciplinary change of placement, including the antecedents and the consequences of the behavior. All of this information is needed to be able to answer two questions. The goal of the MDR meeting is to decide if the behavior is related to the child's disability by answering the following questions. One, was the conduct in question caused by or have a direct and substantial relationship to the child's disability? And two, was the conduct in question the direct result of the LEA's failure to implement the IEP? To answer the first question, the MDR meeting participants must analyze the child's behavior as demonstrated across settings and across time. In order to answer yes to this question, the behavior must be directly and substantially connected to the student's disability. The commentary to the federal regulations provides some guidance on how to make this determination and answer this question. And the commentary clarifies that the intent of Congress in developing these regulations was that the behavior did not have a merely attenuated association with the child's disability, such as low self-esteem. So to further illustrate that, for example, a child with a specific learning disability has difficulty with an assignment that they cannot read. And so they become frustrated and punches and breaks a glass window panel. The learning disability caused the child to have difficulty perhaps processing. This may have led and caused the frustration, which then may have resulted in the behavior. However, the learning disability did not directly or substantially cause the child to break the glass. In this example, the behavior was caused by the attenuated association of frustration. Importantly, the guidance also recommends the MDR team consider any documented behavioral history which may not be connected to the student's primary disability. For the second question, this addresses the implementation of the IEP. Non-implementation of the IEP alone does not mean that the behavior is related to the student's disability. This question should be looked at in three parts. First, was there a failure to implement the IEP? If there was a failure to implement the IEP, what was that failure? And then finally, did that failure cause the behavior that resulted in the code of conduct violation removal? So say, for example, that the IEP for a student with an emotional impairment requires paraprofessional support in the classroom to support the child's behavior intervention plan that is part of their IEP. The school has not been able to hire a paraprofessional and has not provided direct adult support all year. The student becomes upset and is disruptive in class and is removed from their educational setting. And those removals from class amount to a change of placement. Arguably, in this situation, the failure to provide the required paraprofessional intervention to support the child's BIP directly resulted in the student's behavior. On the other hand, look at a situation where a student is supposed to receive speech services to address an articulation deficit in their IEP, but the speech language pathologist has been on family leave and the district has not provided substitute services. The student then violates the code of conduct by stealing the principal's car. Here, there's clearly a failure to implement the IEP because there was a failure to provide speech services. However, this failure most likely did not cause the child to steal the car. Of course, the failure to implement services in an IEP raises other concerns. However, those are not properly addressed at the MDR meeting. Additionally, just to note, the appropriateness of the IEP is not a factor to be considered as part of the MDR determination. But remember, if there is a failure to implement the IEP that causes the behavior, the school must take immediate steps to remedy the failure. So in answering those two questions, what should the discussion during the meeting sound like? The conversation should include an examination of the ABCs, the antecedents, behavior, and consequences of the incident that occurred. Information about the antecedents or circumstances leading up to the behavior may perhaps have the biggest significance to the conversation. Of course, it is often much easier if the disciplinary matter has been adjudicated already. However, this is sometimes not the case. Remember, the team should be reviewing all relevant information in the student's file, not just the latest IEP or evaluation, though those, of course, will be very important. Information presented at the MDR meeting by the parents that was not previously available to the school must still be considered as part of the MDR discussion. However, like any other information obtained outside of the district, the information does not have to be accepted. However, it does have to be discussed and considered. It is also important to discuss observations and progress reports provided by parents, teachers, and other staff working with the student. Disability characteristics should not be discussed globally. The team should talk about what the disability looks like for that specific child. For example, not all students with ADHD exhibit poor impulse control. That could be a global characteristic of ADHD, but it might not be how it manifests for the specific child you are discussing. Again, the team should be talking about what the disability looks like for that specific student. Finally, the team should compare how the disability exhibits in that individual child and compare that to the specifics of the behavior that resulted in the disciplinary recommendation to determine if the conduct in question was caused by or has a direct and substantial relationship to that child's disability. Look at the data and ask, why was the child made eligible under the IDEA and MARS? It may be a good idea to refer back to the IDEA and MARS definitions and eligibility criteria for that child's disability. Remember, though, don't limit the discussion to just the primary disability identified on the IEP for eligibility. The student may have a second or more disabilities. When discussing this question, it's important to look at the whole child and the totality of the circumstances, not just the assigned or suspected eligibility category. When the discussion has been completed, the school should document the information that was reviewed, including information provided by the parent or student at the meeting, and the justification for any decisions, and provide a copy of that documentation to the parent. This documentation should include the student's information, the team member participants, a description of the behavior or the code of conduct violation, all of the information that was reviewed, including the data source and date, and a summary of that information, documentation of the questions that were answered and the outcome of those questions, and finally, the determination. Just a note about students who are not yet eligible under IDEA, but the school has a basis of knowledge, so the student has the same disciplinary protections under IDEA. For MDRs that are held for these students, OSEP, the Office of Special Education Programs, the Federal Office of Special Education Programs, provides the following guidance in their 2019 letter to Nathan. Specifically, the MDR team should discuss whether the behavior is related to the suspected disability. Teams can use questions such as, what were the reasons for requesting the evaluation? Or what behaviors were observed that resulted in the pattern of behavior? Were there any prior conversations about the parents' concerns? And what incidents occurred to prompt a concern or request for evaluation? And these questions can be used to guide the conversation to reach a determination at an MDR meeting for students who are not yet eligible. The answers to each of the questions considered at the MDR dictate the final determination. Again, those questions are, was the conduct in question caused by or have a direct and substantial relationship to the child's disability? And was the conduct in question the direct result of the LEA's failure to implement the IEP? As you see, a yes answer to any question means the behavior is related to the disability. As with the IEP process, the final determination should ideally be by consensus. Like an IEP, this is not a voting or a majority wins process. Ultimately, the LEA will have to make the decision if there is a disagreement. If a parent disagrees with the final outcome, the parent has procedural safeguard rights, and those options will be discussed shortly. The outcome of the MDR will dictate what happens next. If the behavior is not related to the student's disability, the student can be removed pursuant to the district student code of conduct in the same manner and for the same duration as a non-disabled student. However, the student must be provided services that will allow them to continue to participate in the general education curriculum and allow an opportunity to progress toward their IEP goals, though this will be in a different setting. There is no requirement or expectation in IDEA that the student's services be duplicated in that alternative setting. The IEP team must convene to determine what services will be provided and what that setting will be. This setting is not automatically equivalent to the general education homebound services or a homebound setting, though through the IEP process, that may be determined appropriate. The LEA must consider conducting an FBA and implementing a BIP anytime a child's removal is for more than 10 days, if it is considered appropriate. So again, if the behavior is not related to the child's disability, the team has to consider conducting an FBA and implementing a BIP, but they are not required to do so. If the behavior is found related to the student's disability, the student must be returned to the placement from which they were removed. However, the parent and school can agree to change the child's placement as part of a behavior intervention plan, or an administrative law judge can order a change in placement for a student. And if the behavior is related, an FBA and BIP are required. So when the behavior is related to the child's disability, proper behavior intervention strategies must be developed and included to address the behavior for which the child is being removed to prevent the behavior from reoccurring. Finally, if the behavior was due to or the direct result of the LEA's failure to implement the IEP, the school must take immediate steps to remedy that failure. Now, even if the behavior is related to the student's disability, the district can unilaterally remove the student to an interim alternative educational setting, or IAES, for up to 45 school days under special circumstances. And those special circumstances include weapons, drugs, and serious bodily injury violations that happen on school grounds or at school-related activities. The IDEA has very specific definitions of these three circumstances. Weapon has the meaning given the term dangerous weapon under the United States Code Title 18, Section 930. And that term dangerous weapon means a weapon, device, instrument, material, or substance, animate or inanimate, that is used for or is readily capable of causing death or serious bodily injury, except that this term does not include a pocket knife with a blade of less than 2.5 inches in length. And just as a reminder, knife as a dangerous weapon in Michigan is a blade of more than 3 inches. This does not include phones, rulers, books, or other items that don't meet this federal definition. So the student may have violated a code of conduct because they used an object to hurt someone, but this doesn't automatically make the object a dangerous weapon for purposes of the special circumstances removals. So to just be clear, there may be a violation of a student code of conduct that does not amount to a weapon for purposes of this definition, but may still result in a removal or a suspension. Illegal drugs means a controlled substance, but does not include a controlled substance that is legally possessed or used under the supervision of a licensed healthcare professional, or that is legally possessed or used under other authority under the Act or under any other federal law. So a controlled substance is defined again under the United States Code and refers to anything identified under certain schedules in that code. So you have to go and look at the code to figure out if it is a controlled substance for purposes of the special circumstances removal. Serious bodily injury is also defined by the United States Code and is defined as bodily injury which involves a substantial risk of death, extreme physical pain, protracted and obvious disfigurement, or the protracted loss or impairment of the function of a bodily member, organ, or mental faculty. So those are the three special circumstances that are defined under IDEA. A district, though, can also request an expedited due process hearing to request a removal for not more than 45 school days if they believe that maintaining the current placement of the child is substantially likely to result in injury to the child or others. And they would request that expedited due process hearing through the state process, and the administrative law judge can order a placement or change in placement to an appropriate interim alternative educational setting. And the district can request an extension of that 45 school days if they continue to believe that the student belongs in that placement. There is a very high burden of proof for this process. What happens if there is disagreement with the MDR outcome? So if there is disagreement, the LEA representative will make a final decision. The parent, if they are the party disagreeing, then has the option to exercise the procedural safeguards offered in the IDEA. And as with an IEP, anyone who disagrees with the MDR outcome can write a dissent to include in the student's file. In addition to including a dissent in the student's file, parents also have the right to request an expedited due process hearing if they disagree with a disciplinary change in placement or the MDR outcome. The timeline for an expedited due process hearing is 20 school days. And then the hearing officer or the ALJ in Michigan has an additional 10 school days to issue the findings and order. During this process, the student remains in the alternative setting identified by the IEP team, pending the outcome of the hearing. As we discussed previously, a school district can also request an expedited due process hearing to request a change of placement if they believe maintaining the student in the current placement is substantially likely to result in injury to the child or others. The regulations give the administrative law judge, or ALJ, specific authority to order a change of placement for up to 45 school days, to return the child to the current placement, and per 2019 OSEP guidance, order any other relief deemed appropriate, including compensatory education. This same OSEP letter has also provided guidance that the state complaint process is available to parents to address these issues. And there is nothing in the statute that would limit their authority. However, the law does not include an expedited state complaint investigation timeline. This timeline is still 60 calendar days. Mediation can also be used and can usually be scheduled within 2 weeks and many times sooner. And the agreement, if reached, is immediately enforceable. Here is a list of resources that you might find useful. Please search discipline at michiganallianceforfamilies.org for these documents. The Federal Office of Special Education and Rehabilitation Services, or OSERS, has very recently issued new guidance to help schools support students with disabilities and avoid the discriminatory use of discipline. This list includes those documents, which can also be found on the web at sites.edes.gov/OSERS. Thank you so much for tuning in today. I hope this information was valuable to you. Special Education Mediation Services can be reached at our website at www.mikids1st.org. That's mykidsfirst.org. Via phone at 833-543-7178, or via email at info@mykidsfirst.org. That's info@MIKIDS1st.org. Please reach out to Michigan Alliance for Families.org with any questions.
Thanks, Laura. That was a ton of great information, lots to process. As you have questions, as you're thinking about the information from the presentation, do not hesitate to reach out to your regional parent mentor. You can reach them directly by calling 800-552-4821. Also, lots more information on our website, www.michiganallianceforfamilies.org. We have lots of information that we post as it is currently coming out and is on top of current events on Facebook, Twitter, and Instagram. And you've already found the YouTube channel. Please feel free to explore additional videos here. Thanks a lot for joining us today. And Laura, thank you so much for sharing that great information. Michigan Alliance for Families is an IDEA grant-funded initiative of the Michigan Department of Education, Office of Special Education, and Michigan's Federal Parent Training and Information Center, funded by the U.S. Department of Education, Office of Special Education Programs.